bite-sized podcast published by the Meritas EMEA Employment Group. Periodically, members of our practice group will be getting together to discuss interesting and topical cross-border issues. Meritas is a global alliance of leading independent law firms dedicated to helping clients access top-tier legal expertise from anywhere in the world. I'm Sam-Marie Hind, a lawyer and partner at the law firm Howard Kennedy in London. I also head up the Meritas EMEA Employment Group. Welcome to today's episode. Today I'm joined by Hans Hellwig from Graf von Westphalen in Germany, Jeremy Boubil from Vignon-Lebray in France, and by Rositsa Vasileva from DPC in Bulgaria. All of us are employment specialists. As our listeners will know, non-competes form part of a suite of post-termination protections that employers can use to protect their business interests and prevent departing employees from using things like confidential information, strategic plans, and pricing and customer lists for the benefit of a new employer or to set up their own competing businesses. Non-competes can also be used during the employment, and it's worth highlighting that in the UK there's an implied term of fidelity in employment contracts. From a UK perspective, restrictive covenants are void for being in restraint of trade unless the employer can show it has a legitimate proprietary business interest to protect and that the protection sought is no more than is reasonable. Non-competes are the most difficult of the restrictions to enforce as they prevent employees working for competitors for a defined period and can keep people out of the marketplace. The drafting of them to include their duration therefore needs careful consideration. And the UK's last government decided to introduce a statutory cap on non-compete clauses of 3 months. However, the new Labour government has yet to confirm what, if anything, it plans to do. As employment lawyers, I think we'd agree that restricted covenants are a valuable and necessary tool to protect a business, but they must be reasonable in scope and duration. And in today's discussion, we're going to talk about the operation of non-competes in different jurisdictions, which is an important consideration for our clients who operate across a number of countries. Now, I'm going to start today's podcast by asking Rositsa to give us a brief summary of the position in Bulgaria.
Thank you, Sam. That's a really interesting insight for the UK, especially the ones concerning the changes which are ongoing. So that would be interesting. In Bulgaria, we also have quite interesting stipulations, especially considering the opinions of the Supreme Court of Cassation. But generally speaking, we should divide the non-compete clauses into two big groups, which are such clauses which are active during the employment and clauses which are so-called post-termination non-compete clauses. So in terms of the first part of clauses such that are active during the employment contract, these are quite common and such limitation is allowed when it is objectively necessary for the protection of the employer's trade secrets and for avoiding of conflicts of interest. Therefore, as long as there is proper justification, the employer can include such limitations in the employment contract. Also, the employee has a general obligation for loyalty and confidentiality. So these obligations implicitly exclude the conduct of competitive activities during the term of employment in detriment to the employer. However, it's interesting to note that there is one key limitation, and it concerns the post-termination non-competes in Bulgaria, which are basically non-existent because our Supreme Court of Cassation has ruled that post-termination non-compete clauses are void and unenforceable. As a result, although such clauses are in practice often included in employment contracts, they generally do not offer any real protection to employers.
I think that's an interesting point because the UK government was looking at actually banning these non-competes, but decided that actually there was some business justification for them, provided they're reasonable. But can you explain why the Supreme Court has rejected their use?
So of course, yeah. So the court's reasoning is based on the constitutional right of labor of each person, which is included in the Bulgarian constitution, and so it has ruled on a number of occasions that any post-termination non-compete clause basically limits this constitutional right and infringes upon the fundamental human right of labor, and thus such clauses are rejected.
Yeah, it's interesting that there's sort of balancing between the employer and the employee's interest is a bit different in your jurisdiction. I'm now going to ask Hans to give us a summary of the position in Germany. So, amongst other things, and unlike in the UK, I understand that the employer has to pay compensation for the duration of non-compete. So, if you could just set the scene a bit for us.
Yes, thank you, Sam. Yeah, in Germany, we have a lot of legal stipulations, provisions in the commercial code. Although the result often is, as it is as Rosita said for her country, it is very hard to actually enforce them. So the legal setup provides that you can stipulate post-contractual non-competes, but for the maximum duration of 2 years. And if you do so, or if you want to do so lawfully, then you at the same time have to promise the employee a post-contractual compensation, which has to amount to at least 50% of the overall compensation. So if an employee earns, for example, 5,000 or let's say 60,000 euros a month, but gets so it's a year, so it's okay, I'll start again. So if an employee earns 60,000 euros per year and it's 5,000 per month average remuneration, then but gets a car on top, gets bonus payments on top, that is all added up. So at the end, you probably would have to pay him, maybe the overall total is 80,000, and then divided by 12, and 50% of that is what you would have to pay to them for the whole period of the non-compete. So that is always a big discussion we have with clients. Is it really worth paying that amount of money? And it's always a risk evaluation, payment of that non-compete compensation versus what is the risk that actually this employee really harms the business by maybe moving to a competitor, but depends on the position he or she would have at the competitor, and so on and so on. So that is always one big aspect of our practice, discussing with the clients those two, like contradictory topics, risk and payment, and plus. Then you have to very limited, or you have like very strict case law actually on the geographical scope, on the content of the non-compete. So you cannot just say, employee A is working as, let's say, a salesperson for an employer, and you cannot say he or she cannot move to a competitor in the same business if over there, this person wouldn't work as a salesperson any longer, but maybe doing some in-house accounting work or something like that. So you wouldn't probably, the non-compete wouldn't be justified if you know already that is the new job would be something totally different, and only because the business is in the same field, the non-compete may likely not be justified. So that's another big hurdle.
Yeah, I mean,
and overall, maybe one last thing. One last thing is then, of course, as it always in Germany, everything has to be in written form. So you have to have like blue ink on paper. Both parties have to sign it in order to be at all valid. So you cannot, agree like exchanging PDFs or DocuSign or something like that.
Yeah, I mean, I was going to say I can see the similarities with the UK jurisdiction as well. I mean, we have to have them in writing, but I can see in Germany it can get very expensive in terms of having these restrictions and paying for them. In the UK, it's just a matter of at the point you enter into the covenants, you have to show that you've given consideration. And if it's a new contract, for example, it can be that the salary or any bonus payable is the consideration. So it's slightly different. But I think the drafting as well, the tightness and needing to tailor it to what you're trying to protect is the same there. Jeremy, moving over to you and to the French position, are you able to explain to us what kind of conditions employees there have to have in place for the non-compete to be valid? I'm assuming similar to Germany, maybe there's compensation payable as well?
Well, absolutely. I think the legislation in France is quite, similar to what is in place in Germany. Well, firstly, I think we can only apply non-compete clause for employees with a certain level and a certain status. It means you cannot ask like a cleaning lady to have a non-compete clause or a simple worker, but you will need to have some client-facing employees, commercial directors, managing directors, people who are a danger to the company if they leave the organization. So I think that's the first condition. It must be really proportionate to the type of profile of the employee. And the same as Hans, the non-compete clause must be remunerated to a certain level, it cannot be symbolical, but also it must be limited, in time, 1-2 years, not really more. And it must be limited in its geographical scope. So for many employees, you cannot have non-compete clause applying worldwide. So if you're working in a specific region, like for example, the south part of France, then the non-compete clause would only apply to the south part of France. You cannot enforce it in Brittany, in Paris, or in the north of France. So that's really a question of proportionality, but also enabling people to find a new job once they work. So very often we see non-compete clause applying to the whole French territory. So it means you need to get an expatriate if you want to respect it, then move to Germany, to England, to Bulgaria, which is probably very nice, but it's not that easy, for all the family, to adapt to a new country. So I think we are quite aligned with Germany, maybe a little less with Bulgaria, where it looks like the post-termination non-compete is not really, enforceable. But the real difficulty in practice is, even though you respect all these conditions, is to for the company to apply it. Let's imagine one of your employees violates his post-termination restriction and goes to work for a competitor. Then you need to go to the judge and have an emergency procedure. And before this emergency court, you should give evidence that it's obvious that the non-compete clause is being violated. And it's not always easy to convince judges that this is the case. So I would say it's not so rare that employees violating the non-compete clause get away with sanctions, penalties, or continue to work for the competitor. So the reality is you can have very nice and well-worded non-compete clause, but at the end of the day, it would be extremely difficult to prove it at court and to obtain a judgment applying it. So that's the other part of the non-compete, despite their validity, that you're paying a non-compete compensation. In practice, it's very difficult to apply it and basically to have the new employment relationship with your competitor come to an end, thanks to a judge order. So that's the main aspects that lawyers face on a day-to-day basis. Even though we have well-drafted non-compete clause, to apply it, well, you need to be very good.
Yeah. I'm going to come back to the sort of enforcement and remedy position in a moment, but I just wanted to go back to Rosita, this point about non-competes not being enforceable in Bulgaria. So is it a kind of practical approach that you would still include them in a contract as a deterrent? Or is it the case that most employees know that they're not really worth, having in the contract at all and they don't look to abide by them?
So it is a practical approach to include them, although they are non-enforceable, because there are still many employees who are not quite sure whether they can be held liable for breach of the clause. We've seen all kinds of clauses in employment contracts. We have drafted such clauses, but we always recommend to still include them with some reasonable time frame after termination for psychological effect. And but still, it's it cannot be enforced in practice. So we always make that disclaimer and clearly describe what is the situation currently with the case law in Bulgaria. Although I hope we have some changes in the future, because I really think that it is justified, especially as in France, for some positions which are by nature managerial and involve the knowledge of trade secrets and know-how of the company. It really makes sense to be able to deter the employee from disclosing secrets and working for competitors.
Yeah, I think it's particularly important when countries are trying to encourage businesses to invest and to come work into that jurisdiction, to know that they've got business protections that they can use. The deterrent point's really useful and an interesting one. I mean, in the UK, obviously, we're not paying for covenants during the kind of post-termination period, but the deterrent can be really useful there. And obviously, it's very expensive business if you're having loads of legal correspondence going back and forth, or the threat of an injunction hanging over an employee. So moving back to talking about what happens in the event of a breach, and we've covered some of the points already. In the UK, we'd normally have kind of letters before action going between the parties, and we would send those to the former employee and the new employer. Obviously, the new employer has deeper pockets, and you can look to say that they've induced a breach of contract. And also just kind of seeking undertakings to say that the people are going to stop what they're doing and deliver up any of your client's information. And as Jeremy mentioned about moving quickly for an interim injunction or injunction in some cases, or maybe even looking at the remedy of damages. So I was going to ask Hans if you could talk a bit more about the sort of remedies in Germany and what you would do if there was a breach, and what kind of rights of action your client would have against a new employer.
Yeah, thank you. I mean, you would usually, I mean, if you draw a non-compete clause, then you would always include a contractual penalty, so that if the employee is in violation of or there's an alleged breach of the non-compete, and the employee starts a job within competitor, then you can basically, ask him to pay this contractual penalty. And then it would be the easy part on that is that the employee would then, I mean, of course, the employee would say, no, I don't pay. And then you would have to go to court and, and to get awarded the contractual penalty. But it would be the burden of proof of the employee to say, I didn't violate the non-compete. So basically what the employer would have to do is to prove that the non-compete is invalid or not binding. So that's one part. The other part is that you could, of course, try, as an employer, could try to enforce an injunction against the employee to not start a job with this particular new employer. What you cannot do in Germany, or will never be successful to actually plan any or take any action against the new employer. That would only be possible if you had, or if you could prove that the employment of this new employee is a violation of cartel law or competition law, but you cannot, out of the violation of a non-compete of an employee you had, only by the new employer hiring him or her wouldn't constitute any right for the old employer. So for our clients, or it's a very long way, because you would have to prove that the new employer knew about the non-compete and kind of like actively interfered with it, but you'll never manage to do that. So just from a practical perspective, the only cause of action would be against the former employee. With uncertain chances of success. So that's why I always advise to not agree on a non-compete, but rather agree on a longer termination period. Because then you have, during the employment in Germany, it's different from Bulgaria. In Germany, while there's the employment, you always have an ongoing non-competition obligation of the employee due to his a duty of loyalty, so this would be the better protection.
Yeah, I think it's that age-old thing about us being lawyers and liking to litigate and running these points, and then the client having a lot of points that they need to consider about the kind of cost-benefit analysis, and also, I guess, about setting a precedent if you've got a workforce, whether other people are looking to leaving and how they might be treated. Rosita, when we were talking about this before, you mentioned about damages in Bulgaria in terms of restrictions and liquidated damages, and I just wondered if you wanted to cover off that point.
Yes, it's really interesting because a contractual penalty, which Hans mentioned, is not an option under a Bulgarian employment contract. Our employment law is quite protective towards employees. So also we have numerous decisions of the Supreme Court that have ruled that a clause providing an obligation of the employee to pay penalties or liquidated damages in a predetermined amount for breaches of the employment contracts are non-enforceable because we have special rules for engaging of the employee's liability for damages. So basically, in most cases, employees' liability is limited in terms of the amount that could be sought from the employee. In case of intentional damage, the liability is unlimited, but you have to seek a court decision, a judgment for establishing of the damage and the amount of the damage suffered, which could be quite difficult, especially because employers oftentimes do not have clear evidence of the amount of the breach and the extent. Also, a competition law approach is possible, but these are other laws. So you go outside the contractual law into competition law, and the breach has to have certain additional, let's say, aspects in order to qualify for a competition violation. So it could get quite difficult after the termination of employment, but still, if there is a breach, especially in confidentiality, perhaps damages could be sought by the employer based on dissemination of confidential information, although, again, you have to prove it and prove the amount of the damage caused.
Yeah. I think on a final note, because of these kind of letters before action and trying to find a position that suits both parties without needing to litigate, we often will have commercial agreements where we agree to waiver or vary the restrictions. And Hans, I just wanted to ask you about any preconditions of waiving these post-contractual non-compete clauses in Germany, and if anyone else would also like to jump in with their jurisdictions.
Yeah, that's another reason not to agree on non-competes, because if the employer wants to waive it, first of all, he has to do it before the end of the contract. And then even if the employer waives the non-compete, for the obligation to pay the non-compete compensation remains for 1 year. So, or of course, if the non-compete is a year or less, then for that term of the non-compete. But that makes it double expensive if you want, because the employee is not bound by the non-compete anymore, but the employer has to pay for the compensation, despite it not being applicable anymore. Yeah, it's a super favorable position for the employer. So, but that's another reason why you really have to consider whether or not you want to engage in a non-compete clause or want to apply it, because more often we have it that the clients ask, can we get out of this? And you can mutually agree, of course, on an end of the non-compete, but without the pay obligation to pay. But if you want to do it unilaterally, you have to stick to the pay the money.
Yeah, I mean, it sounds much more straightforward in the UK when an employer can decide whether or not it's going to actually enforce the restrictions if they're breached. Jeremy, I don't know if there's any sort of nuances in French law about this position as well, or if it's more straightforward, a bit like the UK.
I think French law is much more nicer for employers because they are completely free to waive the non-compete clause if it's mentioned, of course, and anticipated in the contract of employment. And the big issue is If you, of course, waive the clause, you do not pay anything, so you don't pay any financial compensation. So it's a good bargain compared to Germany, of course. And on the other hand, if you do not waive or you forget to waive the non-compete clause in the right timeline, which is usually before the contract of employment ends, then in that case, you would need to pay for like the 1 year or 2 years financial compensation, month per month, of course, so long as you respect the non-compete clause. If you start violating the non-compete clause, of course, the company would stop paying the financial compensation. But it's really important when you terminate the contract to say immediately, because you don't forget it afterwards, I will waive the clause, so I will not pay you any money on that basis. Or if you want to apply it, you make it clear. But we see in practice that companies very often forget about their non-compete clause. They forget about the contract that was signed like 2, 3, 5 years ago. And when forgetting about this clause, they will not waive it upon termination, and it means that they need to pay the full financial compensation, which is really a pity because sometimes they don't need that protection.
I think that brings us nicely to the end of today's session. If any of our listeners have any questions or comments on this subject, please do get in touch with your Meritas contact firm. We'd be happy to continue these discussions with you. Or if you would like to find out more about Meritas, you can do so via the website meritas.org. That just leaves me to thank Hans, Jeremy and Rositza for joining me today, and we hope you'll tune in next time.